The next case to come before the court is Maxim versus Haley. We have read the briefs, we're ready to proceed to oral argument. Each side will have 15 minutes to prepare or present their arguments, and the appellant may reserve 5 minutes. You may proceed. I'm sorry, I'm just a little concerned because I've never had her talk to me before like that. I don't know what I did, but I did something wrong, so I apologize to you.
Good morning, Your Honors. If it pleases the court, my name is Stephen Haley. I'm the appellant, and I'm pro se in this matter. And this case has often been described as being lengthy and complex, but in fact, it really isn't. There was 37 months of where it just sat, and due to nobody's fault, the file came up missing and things of that nature until Judge Moore issued her opinion. I believe it was July 31st of 2013. And the issue, the major issue, is whether Bank of America is a legal entity. Both trial court judges, Judge Stormer and now Judge O'Brien, vacated the judgment against Bank of America, holding that it was not a legal entity and therefore the judgment was void. And just as an aside, I know counsel for Bank of America has stated that the standard review is abuse of discretion, and that would be true if there was a granting of the 60B motion. But this is a matter of law, and I would argue that it's a matter of de novo review. So, first,
Mr. Haley, I just want to make sure, do you want to reserve some time?
yes, please.
5 minutes?
Yes, that would be fine. Thank you.
No problem, go ahead.
The application, well, first let me just briefly go through this. Initially, the complaint was, the third party and counterclaim was filed against Countrywide Field Services Corporation and then dismissed. Subsequent to Jeffrey Miller, who was the attorney at the time of the case, refiling the complaint, there was a merger, a major merger between Bank of America and Financial Services Corporation, both publicly traded and certainly well known throughout the financial community. It was during the time when we had that major recession going on. And so, as Mr. Miller and I discussed, the application of, and I'll put some glasses on here, the application of, excuse me, one minute here. Of Ohio Revised Code 1701.82A kind of governed. And section 4 of that particular statute indicated that the surviving corporation was responsible for all the claims that were against the previous corporation. And the code also provided that you had the complainant had the option of choosing to continue with the original name, or it could use the name of the new corporation. And that's found again in 1701.82A. So we filed the claim against Bank of America. Now we used the trade name because it was difficult at the time to know exactly who was responsible. And Bank of America Corporation, in their filings with the United States Securities Exchange Commission, stated that there are certain authorized users of the trade name Bank of America, and that was Bank of America Corporation and Bank of America N.A. Prior to the refiling of the claim, all the original contracts with Countrywide Financial Services Corporation were voided, and new contracts were issued, and they were with Bank of America N.A., the banking operation for Bank of America Corporation. As a matter of fact, in the appendix to the supplement, which is the argument made to the trial court, the new contracts all contained the signature of a Mr. Quirk, who was a vice president of Bank of America. And interesting enough, they used the trade name rather than the full name where their signature occurred. So that's the reason for choosing Bank of America. The reason that the trade name was permitted was the application of, here we go, Ohio Revised Code 132910C, which governs fictitious names, trade names, things of that nature. And Section C says that you may proceed against the corporation whether or not it has registered with the state of Ohio using its trade name. And I know that opposing counsel has argued that Patterson applies, but in this case, the actual applicable case law is a Supreme Court case, which is Family Medicine Foundation versus Wright. And it did distinguish between Patterson, which only applies to an individual who's doing business as a sole proprietorship. As a matter of fact, this court here has a case right on point, which is, I don't know if I brought it up with me, but let me just see if I can grab this real quick. I'm at a loss. It's in the brief, but the court does have a case directly on point with that issue. So that's the reason for using the trade name. Secondly, is Judge Moore, who wrote the mandate to the trial court, and it was filed July 31st, 2013, pointed out that she couldn't understand how Bank of or BAC Field Services Corporation had appeared because it failed to comply with the terms of Civil Rule 24. And Civil Rule 24C requires that said irrespective of the basis upon which a party seeks to intervene, the party must comply with the procedural requirements set forth in Civil Rule 24C, which require that a person desiring to intervene shall serve a motion to intervene upon the parties as provided in Civil Rule 5. The motion and any supporting memorandum shall state the grounds for intervention and shall be accompanied by pleading as defined in Civil Rule 7A, setting forth the claim in defense for, and it goes on. The Supreme Court in State ex rel Polo versus Cuyahoga County Board of Elections argued that the failure to comply with Civil Rule 24C is fatal. And so BAC Field Services Corporation, as Judge Moore pointed out in her July 31st opinion, really should not be in the case. They don't have standing to be there.
Mr. Henry,
Yes, ma'am.
I'm aware from the briefs that this issue also went to the Supreme Court, is that correct?
That was on the writ procedendo, yes.
Okay, and was that, and bear with me on this, I charted everything out and then I left my chart, so, but, was that after Judge Moore's opinion?
Yes.
I'm just looking at time frame.
Yes, ma'am, it was. It was after Judge Moore's opinion. It was when it had gone back to the trial court. And due to the turnover in the trial court, as I know you're aware of,
Oh, I am.
we had, and I can't remember the first judge's name, but then we had Judge McKinney, who was a close friend of mine. He had to recuse himself. And then Judge Teodoso had to recuse himself. And that's when Judge O'Brien took over.
I know there's some argument from Appalachia that that Supreme Court case pretty much addressed all the issues, but didn't it address the issue of how they appeared in this case? And didn't at least resolve that issue?
Not to my knowledge, it's not in the decision.
Okay. I'm sorry, go ahead.
And so I'm going to sum it up here because I do want a chance for rebuttal. But those are the reasons, they're statutory in nature. And there are options for choosing who the defendant will be, the corporation found in the merger statute, which also is supported by same statutes across the United States and the other states. Secondly, the trade name is lawful, and that's pursuant to Family Medicine Foundation versus Bright. And lastly, you know, the argument, and it may not be right for hearing depending on your ruling on whether, you know, Bank of America is a legal entity. One last issue, and if I'm getting close to.
Yes, you actually have 9 seconds before you get into your revote.
I'm going to sit down there.
Okay, that's up to you. Okay.
Thank you very
Thank
much.
you.
First, let me apologize. I am under the weather and have a cough drop and some water.
Oh.
In case I start coughing, it's been a rough morning, but I feel like it's maybe calming down a little bit, so. May it please the court, I'm Brooke Batista on behalf of the App.No BAC Field Services Corporation, which is sometimes referred to as Bank of America Field Services Corporation. The trial court correctly vacated the default judgment against Bank of America, formerly known as Countrywide Field Services Corporation, finding that there is no such entity and exercising its inherent power to vacate a void judgment.
Let me ask you a question. Is the whole problem here because they said formerly known as Countrywide?
I'm sorry.
I'm sorry too. I get on attorneys for not speaking up, and then I'm not speaking up.
Well, and I'm having a hard time
Yes,
hearing because
I
of this
understand,
too.
I understand. So is the main issue here that, is the whole argument here, I should say, that they put down formerly known as Countrywide?
Well, the trial court did review that particular, or I think addressed that issue in that it consistently has referred to the third-party defendant as being named Bank of America, formerly known as Countrywide Field Services. The third-party complaint, the amended third-party complaint, the summons that issued from it, the default judgment, all said Bank of America, formerly known as Countrywide Field Services. The trial court, on multiple times now, has reviewed that and said no such entity exists.
And that's what I'm asking you. If he had sued Bank of America, period,
then I think his arguments would have some basis underneath them in terms of looking at Bank of America as a trade name, looking into the issues of merger and whether that has any relevancy here. But as you review the underlying record in the trial court's repeated review of the default judgment and vacating, it comes back to consistently naming Bank of America, formerly known as Countrywide Field Services, which Bank of America has never been formally known as Countrywide Field Services Corporation.
but couldn't you make an argument that that was maybe just, you know, like I sue you and I say, like he said in his brief, you know, like a different name that you go as, and you don't go as that name. That doesn't mean you're not who you are now.
Perhaps that would be the case if there wasn't an actual entity that was formerly known as Countrywide Field Services, but as Bank of America Field Services or BAC Field Services came forth and said, we are the entity that used to be formerly known as Countrywide Field Services. So it puts it into a totally different scenario
So
where
you're saying you can't, for better term, divorce that formerly known as from,
That's-
say,
it-
Bank of America.
that's
It's all
exa-
one.
exactly,
One
because
party.
it directs you to who the actual entity is that is attempting to be sued. Countrywide Field Services Corporation is or its activities are at the heart of Mr. Haley's attempts to file a third-party complaint, though there's no indemnification or contribution claims in that third-party complaint, which I think are a whole nother issue, not before the court at this moment. But at the heart of what he's trying to allege is claims that he believes were assigned to him from subcontractors based on a subcontract between Maxim and those subcontractors that stems from a contract between Countrywide Field Services Corporation and Maxim, not any Bank of America entity, a Countrywide Field Services Corporation contract. And if you follow the flow to that, that's the entity that he believes has some sort of involvement in this case. Has Bank of America as a trade name ever been formally known as Countrywide Field Services? No. Did he sue Bank of America? No. He sued Bank of America, formerly known as Countrywide Field Services Corporation.
Going back to my chart that I don't have with me.
I too forgot my chart. I had a great flow chart and I spent at the time Supreme Court.
That contract was entered into, Bank of America didn't have anything to do with this event.
That's correct.
The merger was subsequent.
The merger was subsequent, so as Mr. Haley pointed out, he filed an initial third-party complaint that named Countrywide Field Services Corporation. That was dismissed for various reasons, and during that dismissal time, the merger between Bank of America Corporation and Countrywide Financial Corporation occurred. And I think that's where it creates some confusion because it makes it appear as if Bank of America any Bank of America entity had anything to do with the heart of the complaint, the third-party complaint, which it did not.
Where did all those pleadings go? That he served? I presume they were served, maybe I shouldn't presume.
I don't know that you should presume that they were served, given the history of this case, but
Let me rephrase that then. How did you learn that there was this judgment against you?
The bank learned of that judgment when Mr. Haley took a sheriff into Merrill Lynch, a wholly separate entity related in some way to Bank of America, and attempted to exercise that judgment in Merrill Lynch.
That's a way to find out.
That is a way to find out.
But the record will demonstrate whether service was processed and whether service was effectuated.
Well, service can't be processed or effectuated against a non-entity. And
I understand that, but I'm just saying that it wasn't like anything was returned and not served.
Whether it was served or not,
It may not have been the right party, that's not what I'm asking you, I'm just saying, there's nothing in the record to indicate that any of the summons and complaint and all these motions was returned.
I believe that that's correct, and I would be speculating at this point. I think we're 8 years down the road as to what happened to those pleadings.
Well, I would
If they
assume
were
that somebody would have filed something to say, hey, we never got served either. Even if that were the right party, they never were served.
Sure, and I think at the end of the day, the question that's before this court, contrary to what Mr. Haley has suggested, is did the trial court abuse its discretion in vacating what it deemed to be a void judgment, in exercising its inherent power to...
Well, if it is a void judgment, wouldn't that be an issue of law, a matter of law? You don't have discretion to determine whether something's void, right?
Well, the court in and of itself has the power to determine whether it's void or not, and I think the trial court is relying on the fact that it has that inherent discretion, exercised it as a matter of law.
Well,
And-
that gets so confusing, I know. Believe you me, been on this court a long time and it gets very confusing. But the point is, the court, in making the determination whether it had jurisdiction or not, because of whether it was a void judgment, you still maintaining that that would be an abuse of discretion review?
Yeah, I guess it is a bit confusing, but is the trial court looking at an issue of law and determining whether it has jurisdiction or not? Absolutely. Is this court, should this court review the trial court's decision on de novo or a abuse of discretion? It's an abuse of discretion. This court should look to the trial court, presume that the trial court did the correct thing, and absent an unconscionable or arbitrary act by the trial court, should affirm the trial court's decision on that matter. Because that is an inherent power to the trial court, there is a deference to the decision made by the trial court in reviewing those issues.
The latest order that came out, does that, to you, this latest from which the appeal stems, does that seem like it's being an order granting a motion, or does it seem like it's sui sponte as it relates to the court's review of the record in this case?
Well, I think potentially it's blended, and I think we presented that argument to this court in that way, in the sense that it appears that the court is exercising its own inherent power sui sponte to say this judgment is void ab initio because it is against a non-entity, and therefore we never had jurisdiction. The case should be treated as if it had never been initiated pursuant to particular case law. But as we presented in our arguments to this court, even if the court wanted to consider the arguments presented by BAC Field Services absent a formal, stylized motion to intervene, I think it has the right to do that. It can and perhaps has treated the motion for relief from judgment as a motion to intervene. That motion for relief from judgment, if you review it, presents the requisite information to cover a motion to intervene, in that BAC Field Services Corporation came forward and said, we have an interest in the property or the law that is, I'm sorry, the interests that are being asserted in the third-party complaint. And this non-entity, Bank of America, formerly known as Countrywide Field Services, cannot protect our interests. We're here, we're ready to defend. We are the entity that is involved in this contract, not this non-entity. So even though it was stylized as a motion for relief from judgment, I think the trial court has every opportunity to treat it as a motion to intervene and review it under that rule.
So as you see the order, then, this allows Bank of America, this allows your client,
BAC Field Services.
BAC Field Services intervention into this lawsuit? Because all it does, I think, is vacate the default. I mean, as I'm reading it.
I think it leaves it as the default has been vacated because it was not entered against an actual legal entity, it was entered against a non-entity. And case law suggests that when a default judgment is entered against a non-entity, it's treated as, well, it is void ab initio, and it is treated as if the lawsuit had never been initiated.
So does the argument remain at the trial court in terms of the motion to intervene?
Well, I think that the entire third-party complaint is treated as if it was not filed against any entity because it was not filed against a legal entity.
I understand that, but go ahead.
No, I'm sorry, I didn't mean to interrupt you if you had something else to
No.
ask. Okay, so you made me think of something, and that is, if it's treated as a motion to intervene, and I think maybe this is what you're getting at, Judge Hensel, what happens to the intervening party?
Meaning BAC Field Services Corporation? Well, I suppose then we go back to the starting point. He doesn't have a default judgment because the default judgment was entered against a non-entity and vacated, and we're back to the beginning. Now, I would, if we go back to the trial court under that theory, I would argue that he has no third-party complaint and he would have to start all over again. Because, as the case law dictates, that third-party complaint filed against a non-entity is treated as if it was never filed or never properly commenced. So even if the court treated, I think this is what you're getting at, even if the court treated the motion for relief from judgment as a proper intervention and actually allowed BAC Field Services to intervene, it's not as if BAC Field Services has been substituted in as a replacement for the non-entity. It's stepped forward and said, we are the correct entity, but if you're vacating the default judgment, it sort of comes full circle back to the fact that there's no lawsuit commenced. And while BAC Field Services may be a party to the third-party complaint, or has intervened into the third-party complaint, there's no claims against it at that point. I hope that answered your question.
Answer mine,
Just to briefly touch, I don't know how much time I
You
have.
have about a minute and a half.
Okay. Just to briefly touch on sort of all of the issues, Mr. Haley raised 3 assignments of error. The first one regarding the trade name, and the second one regarding the application of the merger statute. And I think coming full circle where we started from the beginning of my argument, the fact that Mr. Haley's amended third-party complaint and summons and default judgment are all against Bank of America, formerly known as Countrywide Field Services Corporation. The trial court properly found that neither the trade name, fictitious name statute, nor the merger statute have any relevancy here, because when you come to the heart of it, there's a void judgment against a non-entity, and there's really no need to apply those statutes in the particular facts of this case. And just to touch quickly on Judge Callahan, your question regarding the Ohio Supreme Court's case in the writ of prohibition that Mr. Haley filed against Judge Davis, I think what you're recalling is that the court did review whether the trial court had the ability to vacate a void judgment, and found that yes, it did have that ability. It had the inherent power to do so. The Ohio Supreme Court cited Patterson in finding that that was within the court's discretion to do so. And we believe that the trial court's ruling should be affirmed by this court. Thank you for your time.
Thank you.
And thank you for my understanding of
Hope
why
you get better, hope you get better.
it's that time of the year.
I don't know where to start first.
You have 5 minutes,
I
so
know.
start with that.
First of all, opposing counsel was not in this case at the beginning, so she really does deserve a break in not understanding everything. But what did occur, there was 119 plus filings, court orders, opinions that all went to the address that is now known as Bank of America. It changed during the merger, and not one of them was returned. Certified mail, summons, the whole thing, not one. So, and there's an argument in the motion to vacate that was filed that supposedly somebody in the mail office decided, they passed it on to the person who's appropriate. So they did receive them. Secondly, the acronym, formerly known as, could in this case be substituted and use successor in interest. Same thing. The successor in interest is formally known by the company that it's acquired. It now is the entity that owns both of them. And initially, in the appendix, which is docket 489, Exhibit A is the corporate disclosure for Countrywide Financial, which was what Bank of America Corporation acquired. The merger was between Countrywide Financial, which owned Countrywide Field Services Corporation, and the Countrywide Bank, I believe it is. Bank of America Corporation owns a number of other financial companies, one of them being Merrill Lynch, which was a big deal to save Merrill Lynch from going under. And they own their banking operation, which is a national association, not a corporation. So, when the merger took place, all the companies, all the entities that belonged to Countrywide Financial were merged into Bank of America Corporation, who says that their trade name is Bank of America, and says that Bank of America, N.A., the bank, is the only other person or entity that's allowed to use that. Formerly known as, all the case law, and I did, and it is an exhaustive a search as I could, there are no rules governing the use of the acronyms. They are never considered to be part of the proper name. In some states, there is some rules, but not very specific in terms of the use of the acronym. Formerly known as, also known as, all those acronyms are considered to be surplusage. They're not part of the name. And so, the only name to be considered here would be the trade name, Bank of America. And I did give some examples in the brief, and I noticed that the court alluded to them. Lastly, the matter of having to do with the intervening. That is a mandatory procedure. If you do not serve your motion according to the rules of service, and if you don't serve a complaint that outlines it, it fails. You have no standing to appear in it. I think Judge Moore made that clear in her decision, and which was a mandate, which was the reason that Judge O'Brien probably went into detail concerning, because Judge Moore asked for the legal reasoning to support why Bank of America was not an entity, and secondly, how in the world did Bank of America or BAC Field Services appear without filing a Civil Rule 24C motion to intervene. And, you know, of course we're busy. I certainly know that. I mean, and so the trial court did not really address those issues, even though it's a mandate. And I know we've had that discussion with the court here. And they didn't do that. They didn't go through the procedure of explaining the legal reasoning as to why the application of the trade name wasn't there, even though Judge Moore raised that issue. Why doesn't it apply? You know, isn't it a merger? You know, where's the motion to intervene? So, in light of all those reasons, you know, I would urge the court to affirm the default motion, because it is a legal entity. Bank of America is a legal entity. You see it every day driving down the street. There it is on the sign. It's at the ATM. It's a legal entity. And the Ohio legislature determined that I could use that in terms of suing Bank of America, who acquired lock, stock, and barrel Countrywide Financial. I mean, it is, and there are numerous cases throughout Ohio that have been before this court, federal cases where Bank of America certainly wish they never had acquired Countrywide Financial, because they now are responsible for all the past sins